Shalom, shalom, everybody. Let's talk about your boy. Welcome to Hebrew Television. All right, what I'm about to do is right now, man, I'm about to challenge these Edomites' jurisdiction. Had me a little case where I was going through my little ex, text her about the kids, and she told the little Edomites, she worshiped these devils. So, they call themselves trying to get me on a violation of a restraining order and wanted me to do, I'm, they snuck and had me plead guilty. I mean, plead not guilty. The public defender did that for me. They snuck and did that because my plans were not to plead anything because we don't plead to nobody but to the Most High. But being with that said, I'm gonna let y'all. We're gonna go into the second time of the court case. Let's crack.
You're asking to represent yourself without the help of any attorney. Is that correct, sir?
Yes, that's correct. I have a couple of questions. I wanted to do this at the arraignment, but it got rushed to. Public defender entered a guilty plea, not guilty plea for me. That wasn't.
Let me ask you a couple of questions just to make sure that you're voluntarily and knowingly exercising that right. I just want to go over a couple of things with you.
Okay.
You didn't fill the form out. I have to order.
All right.
You understand that you have the right to an attorney. You're unable to afford one. The court will appoint an attorney at no cost to represent you. You understand by representing yourself, you're waiving your right to have an attorney represent you. Do you understand that, sir?
I'm going to be waiving my right to an attorney.
By representing yourself, you're waiving your right to have an attorney represent you. You have the right to have an attorney represent you.
I don't want to waive my right to have an attorney represent me, but I can have a stand. I would like to have a standby attorney or something, but I don't want to waive that right either. But I would like to represent myself, exercise that right.
Representing yourself, then you are indicating to the court that you don't want to have an attorney representing you in the proceedings today.
Just for today? Or you say, or because it sounds like it'd be I'm waiving it, period. Like I won't be allowed to have one if I say yes, I understand that, and I don't want to.
You can ask the court to have an attorney represent you at a future date, but
Oh,
I
okay.
can only proceed with an attorney
For today?
representing you or not representing you today.
Okay, yes, I understand that. Yes, sir, I understand.
So you understand you have a right to an attorney. One would be appointed to you if you're unable to afford one. But because you're choosing to represent yourself today, you're giving up that right to have the attorney represent you in these proceedings.
Yes, sir, I understand.
You also understand that you are currently charged with 4 separate counts of violating Penal Code Section 273.6 subdivision A, which reads that essentially each of these 4 counts are 4 separate dates in which you are alleged to have disobeyed a court order. One was on November 5th of 2017 that you willfully, unlawfully, knowingly violated the court order obtained to prevent domestic violence and disturb the peace. That was count 1. Count 2 is the same violation on January 4th of 2018. Count 3 is the same violation on February 13th of 2018. Count 4 is the same violation on February 19th of 2018. You understand that you're currently charged with those particular crimes, is that correct?
Actually, no, I don't understand those charges whatsoever. That's why I needed to get the nature and cause of those charges and see what jurisdiction will I be charged under. Because
Well, today, to the purpose of today's hearing is have a readiness conference to decide if we're moving forward towards a trial or if there's going to be an agreement between you and the people to plead to any of these offenses. We've already pled not guilty to the offense.
no, that's the thing. I didn't plead the not guilty. The public defender did. And as I was walking up to right here to get here, a deputy stopped me and asked me about my phone when they started talking. I just heard the judge ask me, how did I hear about the case? I answered this question, and you set the court date for today. And I didn't get a chance to really say
I
anything.
understand, because in that department, there was a not guilty plea that was entered on your behalf, which said in this department to continue moving the case forward to ultimately get to a trial if that's what your choice is going to be. Having said that, since you're representing yourself, I just have to make sure that you understand what the current charges are against you. Those are charges that have been made against you. There's currently a not guilty plea entered on your behalf, but if you change your mind and plead guilty, that's entirely up to you, but I can't give you any advice. You're represented by yourself.
I understand. The thing, I just don't want to enter any plea whatsoever, because to understand if it's common law jurisdiction or amity maritime law jurisdiction, so I can know which way to, to go about defending myself, because both of those jurisdictions is two different.
I can't give you any advice on how best to defend yourself.
I just need to know which jurisdiction I'm in, and then I can take it from there. Whichever, is it common law jurisdiction or amity, what is it? Oh yeah, maritime tribunal, military.
Charged in the county of San Diego for violating the laws in the state of California. You only have a couple of options today. Move forward and set it for a readiness conference to proceed to trial. It's entirely up to you if you want to plead guilty to the offenses. You've already entered a not guilty plea, or one's been entered on your behalf already.
I like to object to that.
I can't do anything about that because if you're
No, I'm not going to. I just didn't want to enter a plea. I just before I want to move forward, I need to know the jurisdiction. That's all.
Well, I've already explained to you what the court's jurisdiction is in the county of San Diego and the state of California with penal code violations that are set forth against you. You have to proceed. Either we're going to go forward to trial or we're not. And I can't control that because all I'm here to do is set it to keep the case moving down the line. And since you're not represented by counsel who can help you go through that process, file whatever objections, file whatever challenges you have to the court's jurisdiction as you or counsel see fit. And the only thing I can do is continue moving the case forward, but I can't do that until I make sure you understand what your rights are that you're giving up as you choose to represent yourself. In order to do that, I have to get through these questions and just to make sure that you understand. You're charged with these crimes, you're aware of what these charges are. I understand you may have some challenges to the court's jurisdiction, but you can file whatever motions you wish to protect your rights with respect to that. It's just not being done in this department today. You also understand that as a result of these charges, subject to fines and potentially incarceration in local custody up to a year. Those fines, by the way, and again, I'm just letting you understand what the charges are and what the potential outcome is if you wind up going to trial. There's a potential charge under each section, these 4 counts of penal code section 273.6, subject to fines, a total amount of fines of potentially up to $727 for each of these offenses. In addition to that, before we move forward, I just want to make sure you have the right to move forward by yourself without an attorney representing you. But I've got a couple of questions for you, so if you don't mind answering these questions, I can know and I can be satisfied that the right to move forward today. How old are you, sir?
I'm 43.
Okay. Are you able to read and write?
Yes, I am.
Did you complete high school?
Yes.
Did you go to college?
Yes.
And did you graduate from college?
No.
What
I
college
got
did you go to?
Long Beach City College.
And are you currently employed?
No, not right now. I'm supposed to be working for Tesla, but this case stopped it. That's how I found out about this case. I've been living in Los Angeles since 2017. So that's another reason when this case was filed in 2018. So that's another jurisdiction problem I'm having with. It's just, I would like to set a motions hearing if you can. If that's what I have to do to file the motions before we move forward with anything. Yeah, I have to have these questions answered before I can move forward. Just like what you're saying, like.
Before I set that hearing for you, the first thing I need to do is make sure that you fully understand and you're confident enough to represent yourself through these proceedings, because I want to protect your rights as well. So let me just
Thank you so much.
ask you a couple of additional questions. You do understand that in most cases, people are not representing themselves. They're usually represented by counsel, and that's because representing yourself without understanding the technicalities of the law, the procedures, that you may have some questions, some jurisdictional questions that you ask, questions about being able to move forward and represent your interests. You understand that representing yourself might not be a wise thing to do, and in fact, representing yourself, you actually may cause more harm than good. There's that old adage that, representing yourself.
That's exactly why I need to know the jurisdiction too before I can make any decision.
I told you what the jurisdiction of the court
Is
is.
it admiralty law or common law? Just this one of the two, because Article 1, Section 8, Clause 17 of the Constitution grants the courts two different jurisdictions, period. So I just need to know which one, and then I can understand the proceedings better. This is common law jurisdiction?
We have statutory law in the state of California plus common law as enunciated by the courts of this state.
So this is common law jurisdiction right now, then, right?
As I've indicated, it's statutory law as supplemented by common law as set forth by the case law. It's interpreting the statutes of this court's jurisdiction.
That gets confusing because I haven't read anything on the statutory law procedures or how to go about it. If it is, can I at least get the information on how to get the public way to go about it, the public rules on the statutory jurisdiction?
Again, I can't give you legal advice on how to proceed and represent yourself. The only thing I'm trying to do today is decide whether or not you have enough information before you that you can represent yourself confidently. You have the right to represent yourself through the proceedings. Today's proceeding is merely for me to determine whether or not I'm going to allow you to continue representing yourself. I'll set another readiness hearing, at which point in time, if you want to make whatever jurisdictional challenges or whatever arguments you want to file with the court with respect to the court's ability to proceed, you have every right to do so. But until that time, I can't do any of that until I make sure that you understand that I allow you to represent yourself. You're not being accepted any special favors. You're not going to be given any special treatment because you're representing yourself. The court can't give you any legal advice. You understand that, yes, sir?
Mm-hmm.
You also understand the crimes that are being charged against you have to be proven by the people. There may be possible defenses to these charges, and without the assistance of counsel or formal legal training, you might not be aware of what the elements are. You might not be aware of what the potential defenses are. You raise this jurisdictional challenge, I suppose, and you have the right to file whatever pleadings that you want to raise that in a more formal way. But there may be defenses to the crimes that are charged against you that you might not be aware of because of your lack of legal training. But you're going to be responsible for knowing the law that's applicable to your case if you represent yourself. You understand that, sir?
No, not that last part. You're saying that I could get criminal charges against me for not knowing procedures?
No, sir. There are criminal charges pending against you right now.
Oh, okay.
There are potential defenses to those charges that you may not be aware of because you lack legal training.
I get you.
By representing yourself, you are basically taking the responsibility to know the law and know the defenses.
Okay.
You understand that you're waiving the right to have an attorney do so on your behalf.
Yes, sir. I understand.
You also understand that there are certain procedural rules that we have to comply with in terms of moving the cases forward, what happens in each particular court, what happens in each particular stage of the case, such as making pretrial motions, selecting a jury, opening statements, cross-examination of witnesses, understanding what the evidence code is, presenting evidence on your behalf in which to do so, making motions during the trial, making arguments during the trial, representing yourself in probation or sentencing hearing. And you'll be governed by the same rules as an attorney is if you want to go through those processes on your own. You understand that, sir? All right. You also understand that the prosecution is going to be represented by an attorney, someone who went to not just college but law school and has been hired by the prosecuting office. And they may be very skilled, but treat you. They are going to treat you just like they would treat any other attorney representing a defendant. That is, they're not going to go easier on you because you have to represent yourself.
Yes.
I also understand that there's important forum. You and I are engaging in a conversation right now. You're being very respectful to the court. I appreciate that. I'm trying to answer your questions. You're answering my questions, and I do appreciate that. There's certain courtroom procedures that we have to follow, and I'm going to hold you to the same standards as I would hold any attorney that's standing before the court as well, because normally people don't speak to the court unless they are attorneys, or in your case, if you're representing yourself. Do you understand that, sir?
Yes, sir.
Right. And you understand that if your pro per status, meaning this, your status of your self-represented status is terminated at a future date, you will still have represented by a lawyer appointed by the court who might take over the case at that point in time, at whatever that stage is in, and they may be in a disadvantaged position if they take over right before the trial, and they come in and they ask for more time. The court may not give more time. So by representing yourself today, if you ever choose to have an attorney represent you in the future, they may be disadvantaged by coming in at a late stage of the case, so to speak. Okay. You understand that because you're representing yourself, but you're also a defendant, there's a possibility that the trial judge may impose certain restrictions on you that they would not otherwise impose to other attorneys. For example, your ability to enter into the well, approach the jurors, approach the witnesses, that might be constrained based upon either the nature of the charges or the manner in which you're proceeding. Is just because you're not an attorney, so the court may issue a protection of witnesses or jurors and may require you to stay at counsel table as opposed to going freely in the court.
I don't understand that one because that kind of sounds like discrimination. If I'm not found guilty yet, then I'm trying to present myself to be.
Again, and I'm not indicating that any of the are going to happen, but depending on how you're proceeding and how you're representing yourself, the court may.
Oh, okay, I see what you're saying. Okay. Depends on how I see what you're saying. Yes, sir, I understand that.
You also understand that it may be difficult to obtain continuances if you're representing yourself unless you're showing good cause, and it may be difficult for you to make that good cause showing, so that if you can't, and so the court may not grant you a continuance if you ask for a continuance, and continue proceeding with the case and moving towards trial, because you've got a burden to show good cause to get granted continuance, and if you're not skilled in the law, you may have difficulties overcoming that burden. You understand that?
Yes, sir.
Okay. You also understand that if you, depending on the stage of your case, if you give up your right to represent yourself and you want to have an attorney represent yourself, there's a possibility the court may deny that request and may require you to proceed without the services of an attorney. Yes, sir?
Mm-hmm.
All right. You also understand that you may not automatically be entitled to an investigator or a legal runner, someone that can file documents on your behalf to provide assistance to you. In order to obtain that kind of assistance, you may have to file a formal written motion before the court to justify your need for it. If we appoint one on your behalf, they'll be required to follow the procedures that the public defender's office normally is required to follow for obtaining assistance. You may not be able to obtain all the assistance that you want or feel that you need because you're representing yourself. Do you understand that, sir?
Yes.
You understand that you don't have a right to advisory standby or co-counsel. The court may at a future point in time grant that to you, but for purposes of today, you're telling me that you want to proceed and represent yourself as you move forward today. Is that correct?
Yes, sir.
You understood the warnings, the admonishments that I've given you today, sir? Yes?
Yes.
And so despite those warnings, despite those admonishments,
Yes, just for today, yes.
I've made inquiries to understanding the charges, the nature of the proceedings, your background, your training, your education. I find that you've made a knowing and voluntary and intelligent waiver of the right to counsel. Today, you're being granted the right to self-representation to represent yourself today.
Thank you, sir.
And so we'll enter that into the minutes. In the meantime, what I'd like to do is today was set for readiness, meaning that where are we proceeding for trial today? We have a trial date that's contemplated for January 28th. What I think that I'm going to do is now that you're representing yourself, I'm going to give you a little bit more time to get yourself ready for trial. So I'm going to give you a new readiness date today, and I'll set them out for trial in the future. Okay.
Okay. Is there any? Well, there's no way I could take back that not guilty plea because I wasn't ready to enter a plea on the first one.
The plea that we have is guilty.
I really said that. Okay.
Right now, what we're going to do is, let me just reflect again on what I said. Today's the original readiness date. That
Right.
means, are we ready to proceed to trial? Are the people ready to proceed to trial? Because it's currently scheduled for January 28th. So my question to you, sir, is that you want to confirm that trial date of January 28th?
Actually, Your Honor, I would like to move for dismissal right now.
Well, I'd be more than happy to consider your reasons for dismissal if you file some sort of written motion before the court giving me the reasons as to why you think dismissal is warranted.
Yes, sir.
And given the fact that you've indicated that, given the fact that you've raised some jurisdictional issues, you're probably required to do a little bit of research, file something more formal with the court so we can understand your reasons and your case for seeking your dismissal. counsel.
Okay.
What I'm gonna do is I'm gonna set another readiness date for this case. And then, I'll ask the people, am I gonna confirm the same trial date and set a like an intermittent readiness date until there may be motions that are filed, or would you like me to set the trial date out a little further?
At this point, Your Honor, let's take alleged conduct's almost a year old. I'd rather keep the trial date the same.
So, sir, what I'm gonna do is, I'll set another readiness date for you. That way, now that you're no longer represented by counsel, this is a new situation, a new circumstance. I'm gonna give you a couple of weeks to kind of figure out what you wanna do to proceed. Do you wanna file any motions before the court? Are there any things that you need to do before we go to trial? I'll confirm the trial date today, which is January 28th. I'll give you about 2 weeks, before we have another readiness date to come back into court. We'll have a conversation with the court as to whether or not you want to change your plea, if you still want to go forward with your trial. You have every right to communicate with the people and discuss the potential plea bargaining with the people, discuss the way in which the case may be dismissed, or the way in which there may be other proceedings involved other than a jury trial, which fines and the incarceration that I discussed with you. That's between you and the people. If you don't want to plead, if you want to go forward with your trial, we'll get that trial date. It's currently set for January 28th, but based on what I've heard from the people, I'll keep that trial date, but I'll give you a new readiness date, and that new date will be, Madam Clerk.
Your Honor, there's not enough time between now and trial to set another readiness. Today is the actual approved date.
I'm okay for a short continuance, whatever.
He wants 2 weeks.
So, sir, if I give you about 2 weeks in order to gather all your information, gather all your evidence, if you wish to present evidence, have conversations with people, potentially plea bargaining, so to speak. We're not going to be able to go forward for jury trial, which is currently set for January 28th, which means I can push the jury trial out a little bit more if you want a little bit more time. Would you like that?
Sure, that'll be fine.
So there'll be a time waiver for the jury trial. I'll give you a new readiness date and a new jury trial. Those 2 dates will be, Madam Clerk.
Readiness will be on January 22nd at 8:30 back in this department.
Okay.
And the new trial date will be February 12th. 8:50, yeah, that's a holiday. February 13th, 8:50 department.
Okay, so that trial date may or may not go forward depending on what happens with the next
That's a
readiness
readiness,
date and
okay.
what happens with your conversations with people.
Okay, all right,
So
thank
I'll see
you.
you back in this department on the, what was that date, Madam?
January
22nd?
22nd.
January 22nd.
All right, thank you. You have a great day. Can I get a card from you?
Here's my counterpart. You know what, let me write. What do you want, a phone number or email?
Just in case we do need to communicate.
Good morning, Your Honor. Deputy Public Defender Joe Hart on behalf of the Borough.
Is there a certain time of day that's better to call?
Charged on the record. Offers and negotiations.
Perfect. All right, thank you. Hello, good evening, Your Honor. I'm pretty good. Yes, ma'am. They already did that, but my understanding, me and the district attorney decided to dismiss the case.
That is correct, Your Honor. Matt Hardy on behalf of the people. Due to, or in the interest of justice on this case, people are going to be dismissing this matter. I did have a conversation with Mr. Brooks, and we've come to a resolution, and I want to encourage him that it's not necessarily because I was intimidated by him and his pro per status. I don't want to necessarily encourage him to become pro per if this were to happen again, but in this case, it is the right thing to do, and we're going to move to dismiss.
Well, there you go. And I assume it's okay to do the thing.
Yes, ma'am, it is.